Hi, I'm Greg Dell, and I'm here with attorney Alex Palamara, and we're going to talk about a recent case that just came out against the Standard Insurance Company. And a little background about the case: it involves a lawyer that was practicing environmental law. She had a long-term disability claim based upon anxiety and depression as her disabling condition, and the Standard denied her claim, which eventually was reversed by the First Circuit Court of Appeals. And the issues that you're going to discuss that are key in this particular case have to do with how they evaluated her occupation, and then you're going to discuss some of the other key issues that came up in this case that could benefit some of the people watching this video.
Correct. So a few things from this recent case. The policy is kind of a unique policy. It's an own occupation definition of disability policy. That means that the definition of disability does not change ever in this policy. It's a good policy. Your employer provided her with a pretty decent policy here. So that means that in order for her to be considered disabled, she has to prove that she's unable to perform the duties of her own occupation. And this policy in question actually said for this attorney that it's actually it's subject to how she performs the legal work, what kind of law she practices. In this case, an environmental attorney. So in order for her to be provided benefits, she has to prove she's unable to perform the duties of her own occupation, environmental law. The other thing that's unique, so there's no change in definition of disability, which is a great policy. Most policies, after 2 years, you have to be unable to perform the duties of any occupation, which is when most insurance companies deny claims. Unfortunately for this environmental attorney, the Standard denied her claim from the get-go. To give a little bit more background, she stopped working in November of 2011. Actually, she kind of slowed down working in November 2011. She realized that her depression and anxiety were kind of building, and she got to a point where she had to slow down. Her employer worked with her, said, hey, listen, cut back a little bit, maybe do some pro bono work, maybe do some committee work, whatever it may be, till you get feeling better. A few months later, by January of 2012, she just realized she couldn't keep up with it at all. Her employer said, make a claim for benefits, and she did so. So what the Standard did here was they looked at her claim. They looked at the Dictionary of Occupational Titles, which they often do. They saw that the Dictionary of Occupational Titles does not define what an environmental attorney is, only defines what an attorney is. They applied that description of being an attorney to her restrictions, limitations, and they said, listen, we don't think you satisfy the definition of disability. So first and foremost, they said that we don't think you can perform the duties of an attorney. They didn't say environmental attorney. The other thing that the Standard did here was they said, we don't find you disabled from November when you started slowing down. We found you disabled from January of 2012. So the Standard ruled against her. She filed a lawsuit. She lost that lawsuit. It went to the First Circuit Court of Appeals, and now, thankfully for this attorney, this environmental attorney, I should say, she's proved victorious in that she was right in making this claim. Now, the reason why, a few things I want to say here. The reason why it's important to note why the Standard decided to find her disabled in 2012, in January 2012, instead of November 2011, is because they were going to save money here. When she slowed down working in November 2011, her income went way down. And the way they figure out how much your monthly benefit would be is by taking, in this policy, the your pre-disability earnings from your prior tax year. So if they found that she stopped working in 2012, they said, hey, 2011 is the prior tax year. Her income was way down because she basically didn't work at least 2 or 3 months of that out of that year.
Right.
So the monthly benefit's way lower. So what the judge said here is a few things. The insurance company should have looked at her job as the policy defines, and it should be as an environmental attorney, so they were wrong there. And they were wrong in backdating and not backdating the claim to when she stopped working as her own occupation, environmental attorney. And the judge actually gave a great quote. It actually quoted from a previous case, and the judge said, a disabled person should not be punished for heroic efforts to work by being held to have forfeited entitlements to disability benefits should she have stopped working. So basically the judge is saying, you know, this person tried not to make a claim. How can you possibly hold it against her when she's trying not to make a claim against the insurance company? So the judge was right in this case. It's good case law for anyone out there who's thinking about making a claim, who's trying to tough it out and be heroic, and is scared the insurance company is going to use it against them, and they probably will try to use that. But this case is a case that we can rely upon in the future.
To say that you can basically backdate the claim, even though you're working, you could still be disabled. And we get that a lot in cases too, where somebody's working, they get fired, and then they try to file the claim and say, hey, I was disabled even though I was there. And the courts have found also that person can be disabled.
Exactly. I mean, it's an old argument the insurance companies love to make, and it's a really a credit to the credibility, I guess, to the person making the claim, that they try to tough it out to the point where their employer had to let them go because they couldn't do it any longer.
Right. If you have a claim with the standard insurance company, no matter what stage it's at, anything from the application through an appeal to filing a lawsuit, feel free to call any of our lawyers. We'll always offer you a free consultation. We can help you anywhere in the country, and we look forward to the opportunity to discuss your claim with you.